Well, I want to welcome everybody. My name is Chris Aiken. I am the chair of the Downtown Business Association, and I'm very happy to present on behalf of the Downtown Business Association part two of our series on reopening. Today, we're going to be talking about the fundamentals of safe retail reopening. I'm very happy to reintroduce our two panelists. The first is Javier Carbone. Javier is a San Clemente-based employment law attorney and workplace investigator. And I also am very proud to welcome Shannon Wolf. Shannon Wolf is an employment law attorney based in San Clemente. She advises and represents small and medium-sized businesses in employment matters. Just a couple housekeeping matters. The panelists are very happy to entertain all your questions. There will be a running chat box, and feel free to answer any questions that you have. And I will communicate them. And also, I will be sharing shortly a Dropbox link. The Dropbox links will have all their materials for that they'll be referencing today. So without further ado, I'd like to turn it over to our panelists. Thank you, Javier and Shannon, and let's start the webinar on fundamentals of safe retail reopening. Thank you.
Thank you, Chris, and thank you everybody for attending. First, on the housekeeping side of things, once you share that link, Chris, they're gonna have the opportunity to download several documents. We have, for example, something that looks like this. We're gonna be sharing a sample of a prevention plan. We're going to be sharing also the guidance and the checklist, and we're going to be making reference to these documents, but of course we want you to have a copy of them, and you can get them from the link or you can ask us afterwards. And I believe that the organization also has a page on the internet that has a link to the downloads. So we have a lot to cover. I'm going to talk very fast and try to get as much information as possible, but we want to cover some areas. So let me just begin by saying that I would like to frame the dialogue or conversation that we're going to have this afternoon in the perspective that this is about risk management. There are some things that business owners need to do to change their business model to make sure that they comply with the government recommendations to avoid the spread of the virus and to prevent COVID-19. And we're going to cover that. But also, as attorneys, we want to cover the legal risk associated with being in business during a global pandemic. And thinking about that, I just want to say that there are three areas which I think that business owners should be aware. And the awareness of these three areas of legal risk are going to inform the conduct and the actions that we take to avoid that legal risk and to manage the risk. And to be specific, the first area has to do with the health and safety of the employees. Employers have a duty or obligation to provide a safe work environment. And that means that as employers, business owners have to do things and they have to take measures and follow rules to make sure that the workplace is safe. Well, because of the global pandemic, there are specific things that need to happen and steps that need to be taken to comply with that obligation or duty to provide a healthy workplace. And this is important because already it has been on the news that some employers have received class action lawsuits. For example, Amazon has been sued, McDonald's have been sued under the allegation that they failed to take enough preventive measures to ensure a safe work environment. Now, I have a duty to tell you that some employers have been sued, but I also have to tell you that at least from the OSHA perspective, the Occupational Health and Safety agency in charge of investigations, they have said that they're going to follow a good faith effort standard. And that means that as long as the employer is doing a good faith effort to try to prevent the spread of the virus, there should not be an enforcement action. So we should be mindful and aware, but at the same time, take any measure that is in good faith to prevent it. The second area has to do with discrimination, equal employment opportunity. Those laws are in the books and they're not going away because of the pandemic. So we have to be mindful that there are rights of people related to medical conditions and disabilities, and those rights have to be observed. And the third area have to do with wage and hour issues. Under the employment laws, we have to ensure that payment of wages are followed, that those rules are followed, and there are some specific things that we're going to discuss about the payment of wages. So if you forget everything we say, just remember that there are 3 areas, and as long as you do a good faith effort to try to comply, you should be in the clear from the legal point of view. Shannon, I think we're going to talk about now about the different regulations.
Sure, yes. Couple preliminary points I wanted to make is that, first of all, there are various regulatory agencies that are involved. There are various multiple levels of regulation. We've got the federal, the state, the county, and even at times the city. Different regulatory agencies that are releasing guidance are the EEOC, the DFEH, OSHA, CDC, and I could list a whole host of acronyms.
The EPA.
Yep, and it can seem really overwhelming and information overload. But the important rule of thumb to remember is you should follow whatever is most restrictive. So the state basically the state's guidance is the minimum bar, and if the county has a more restrictive requirement, you should follow the more restrictive requirement. The other thing is that this is an evolving situation. So even though you're attending this webinar today, you're still going to want to check the guidance, see what updates there are as new information gets released. These guidelines are, most likely going to change. Orders can be modified, and so you just want to stay up to date. A couple good resources to look at are the state's COVID-19 website, has lots of information, lots of links to other guidance from other agencies, and then also the county's website is another good resource as well. So we want to talk today about the guidance released by the state on retail. The first thing you need to do, what do you need to do before you reopen? The first thing that you need to do is perform a detailed risk assessment. And what that means—
Chris, I'm sorry to interrupt. If we can show that slide on the steps. I'm sorry, Shannon, go ahead.
No worries.
Will do.
If Chris will pull that up while Absolutely. I'm talking. So this slide will show you the steps of what steps you need to take. There's 5 steps. The first, as I was talking about, is performing a detailed risk assessment and implementing a site-specific protection plan. So the risk assessment, you're gonna look at your work site and see what are the risks here of someone catching COVID. What are the frequently touched surfaces or areas? Where is there a lot of traffic? Where is there crowding in the store? Where will people be less than 6 feet apart? How can we minimize that? So the first thing you want to do is just assess your risks. And then the next thing is creating a site-specific protection plan. Everybody's required to have a protection plan dealing with COVID. And we've made that easy for you in your materials. There is a draft plan. So just take a look at it. You can tweak it to make it, if you want to make it more specific to your business. But basically this is a plan on what kind of measures you're going to take to prevent the spread of COVID and protect your employees and customers. You're required to make somebody responsible for the implementation of the plan. So we'd suggest, the business owner or the operator should be in charge of that. And then the next thing you need to do, step 2, is training your employees on limiting the spread. So you not only want to have this plan, you now want to train your employees on what that plan is. The guidelines also go over some specific things you need to include in that training, such as educating your employees on COVID-19, how to prevent the spread, what are the vulnerable populations, also how to screen themselves for symptoms or temperature checks, and the importance of course, of hand washing, physical distancing that we've all heard about, and wearing masks. Now in Orange County, the masks are required in the workplace. And also when to seek immediate medical attention. There's in the guidelines, it identifies situations when you should tell your employees they need to seek seek guidance, medical attention, and then of course not to come to work if they're having any symptoms, have been diagnosed, or living with somebody or been in close contact with somebody that's been diagnosed with COVID-19. And even better is just to tell them, if you're sick, don't come in. Better safe than sorry. If they have any kind of sickness, not to come in. And finally, educating them about what your policies are on leave, whether that's your own policy or a government-sponsored benefit like the Family First Coronavirus Response Act. And then also, finally, you should document that training, keep some documentation showing that you conducted the training. And you should try to have that training, if you can, do it remotely. If you can't, just make sure that you're complying with the physical distancing requirements and everybody can spread out. The last thing that you're required to do is to post a checklist that's specific to retail. And we've included this in your materials. This checklist pretty much sums up what the guidelines are, which Javier is going to discuss with you. So you're required to post this checklist at your entrance where it's visible to customers and your employees. And with that, what's called an attestation, we've also included that in the materials. And it's basically, the attestation is certifying that you've taken these steps that we've discussed here today, and that you're following the guidelines. So you want to post that as well, sign it by the business owner or operator, and post that with a checklist. And now Javier is going to talk to us about the control measures in the guidelines.
Right. So one thing before we move on to that, I wanted to mention that I think it's a good idea to post this in the entrance of your business. If you ask me, I will put the whole checklist and the attestation on the door or outside in a placard or somewhere that it can be seen, not only by the public, but in the best case scenario by an inspector. If an inspector from the county drives by and they see your business with an attestation and the checklist, and the next business doesn't have it, guess where they're gonna stop, right? So it's required. Most business people don't like it to put it because it looks ugly, but I would. Now, moving on the actual guidance, which is the 12-page document that includes all of the things that we must do. Please read it, download it, understand it. But I want to go over what is important. And what is important, number one, is the control measures that have to be taken. And the first and single most important control measure, I think, is either taking the temperature of employees when they come into work, or screening for symptoms. And there are two ways to screen for symptoms. Either you screen for symptoms at the beginning of each work shift, or you ask the employees to self-check at home and instruct them not to show up to work unless they have self-screened and they don't have any symptoms, with the guidance, of course, that if they're sick in any way, to stay home. Chris, we have a checklist that is like a flyer published by the CDC. If we can put that up. This is part of the recommendation from the CDC for the employees to know and be aware of what the symptoms are. And this should be covered when we do the education piece that is required under the checklist. But I think it was a good idea maybe to hand this out and give it to employees so they can do the self-check at home, or we're gonna do this self-check or the check when they come to work at each shift, or we're gonna take temperature. In some places, they're taking the temperature. The second area, well, we have, and we look at Chris's desktop, yeah. So those are the symptoms, right? Cough, fever, chills, muscle pain, shortness of breath, sore throat, and other symptoms that have been identified. It will be a good idea to share this with the employees so they can self-check at home, or to create a checklist or a questionnaire for the employees to complete at the beginning of each shift, or to take the temperature, or both. So Chris, thank you for sharing that. The second area, of course, is face coverings. Face coverings are important in the sense that they are required according to the guidance of the county. And there's also a strong recommendation for people to wear face coverings. This has become, unfortunately, a political issue. I don't know why, but it has. But the reality is that wearing face coverings is for the protection of others. And in the case of retail, any client-facing employee should wear a mask. And in the case of cashiers, they must wear a face covering when facing the public. And also, cashiers should have a barrier, and the guidance suggests be made out of plexiglass to protect them from the public. So the face coverings and any barriers to protect the employees should also be implemented. Anything within reason that will help to protect the employees and to promote physical distancing. Some businesses have a small portable plexiglass, and some places now look like a bank or a check catching place. It depends on what you want to do at your place, but definitely the guidance requires for employers to, in good faith, try to take measures to prevent the spread of the virus and infection. The next area is signage. The guidance talks about signage to promote the wearing of face coverings, signage to promote the physical distancing of at least 6 feet, and it makes reference to visual cues like tapings or postings or stickers or anything that will remind people that there are ways to keep physical distancing. Another suggestion is to have one entrance and one exit and the flow of people in one way only. In some businesses with 2 doors, that could be achieved. If you only have one in and one out, well, that's harder to do, but anything that will promote the flow of traffic so people don't cross each other, so people keep a distance, so employees know where to stand, customers know where to stand, including considering asking people to wait outside. In some places where you go now and show up, they will just let you in like nothing happened. And in some places where you show up now, they'll ask you to wait outside. And in some places they even say, give us your cell phone number and we'll text you. Go to your car and we'll text you when you're ready to talk to you. Any of those measures will help. And the decision-making process is that the stricter you follow the guidelines, the less legal risk you're gonna have. In managing the risk, the more you do, the less of a legal risk. If you do nothing, well, you might find yourself being a defendant because there are too many attorneys out there. But all kidding aside, the next area that these guidelines talk about, they have to do with cleaning and disinfection. And it is important to establish a cleaning and disinfection protocol and to follow it. So if we're going to commit to doing a certain type of cleaning at a specific period of time, we should observe that and do it regularly. I have to say that the cleaning products have to be approved by the Environmental Protection Agency. So the EPA has a website with a list of approved products for disinfection. And we have to disinfect any shared tools, any touchable areas. And in the case of shared tools, they should be disinfected after each use. What does that mean? Well, if we share a pen, it should be disinfected each time somebody uses it. But on the, for example, the computer pads to take payments, that also technically should be wiped and disinfected after each use. In some stores, they go to the trouble of cleaning after each customer checks out. In some places, they only do it at a regular interval, and in some places they don't. So again, the more you do, the better you are at preventing the spread of the virus. And we talked a little bit already about the plexiglass and other barriers and the necessary cleaners that are approved to kill the virus. The next area under the guidance that we want to discuss today is the physical distancing guidelines. It is important to have visual cues and to take any measure to promote people observing the physical distancing of at least 6 feet. How can retailers do that? Well, one way to do it is to limit the amount of people that come into the space. And the suggestion is to adjust the maximum capacity to 50% of what you are maximum allowed to have. So try to pare it down to half of the people that you're supposed to have inside your place or premises. Also establishing physical cues like stickers on the ground, like taping or anything that will suggest where to stand and how far apart you should be. Signage on the walls and anything that promotes physical distancing. Another way to keep physical distancing is to have curbside or outside pickup. So people can go and pick up their merchandise outside or to do it at the curbside. Also, the face coverings we already talked about. Some of these are repeated, the physical partitions and visual cues. Adjusting in-person meetings. The guidance suggests that we should not have in-person meetings, which is kind of contradictory to training employees. So let's be mindful that if we're going to have a training session for employees, we shouldn't do it in a meeting, because any group of people getting together could be a source of infection. So we have to adjust and try to do as few in-person meetings as possible. Another suggestion is to have priority, or to have a specialized or dedicated shopping time for people who are vulnerable. Those people who are over age 65, or those people who have a chronic condition, we can establish and should establish a priority shopping time, usually near the time that this disinfection has happened. So they come in with a priority when the place is disinfected and clean. And the vendors, anybody who's a vendor who brings supplies or merchandise or in any way to provide a service, the guidance requests for retailers to ask the vendors to comply with the guidance and to adhere to the rules, and to also take measures to prevent the spread of the virus, to maintain physical distancing, and to observe good hygiene, which is a point that we're going to cover later. But I want to mention that we should either provide tools like disinfectants, hand washing stations, allow people to take frequent hand washing breaks, or to provide gloves as a substitute for hand washing. But anything that we can do to promote the hand washing by employees, by vendors, and maybe even customers, that will be in compliance with the guidelines and will help the health authorities prevent the spread of the virus. Shannon, I think we're going to now switch to another consideration for retailers, right?
Sure. Before we go on, Chris, were there any questions?
The one question is you kind of talk, what are some of the best resources to find this information? I mean, like, are there some websites as far as getting these, like, I know you provided some with your materials, but is there like dedicated websites or resources to find all this information that you're talking about as far as signage, physical distancing, anything like that?
For the signage, there are, I think most every website has some sample signs. I think the Orange County website, the CDC, Cal OSHA. I would start with the guidance, and in the guidance, there are links to the CDC and Cal OSHA, and reading those guidelines too. There's a lot of overlap, but all those agencies have different signs that you can use and that you can post.
Right. So going back to the comment that Shannon made, that as business owners, you should follow the stricter rule. Definitely the California Cal OSHA guidance is stricter. So this is where I would begin. And the state of California has a resilience roadmap. And within the resilience roadmap website, there are links to the guidance and to the checklist. So that's a really good source and should be the #1 source. But the state of California also has a COVID-19 website, which is really good. And there's more guidance there. The county has its own. And there's an agency called the Labor Workforce Development Agency, or LWDA. It's a fantastic website. So this can become overwhelming very fast. My recommendation is just go there and find what you like and use all tools to ensure that you keep physical distancing, good hygiene, and protection. Disinfection, and we should all be okay. But we want to talk now about the employment law considerations and those aspects that have to do with dealing with the employees, because one thing is to protect the employees, the other is to protect the public in general. And now let's talk about the laws that were in the books, and now we have to make sure that we comply. And the first, I think, area of importance is the leave policies. In California, we have paid sick leave, which means that anybody who has a medical condition could take up to 24 hours or more, depending on the policy of the employer, of paid sick leave. Well, that's still in place. So if somebody has a disease, illness, or needs to take medical treatment, they can use paid sick leave. But on top of that, the federal government passed a special law that is a temporary law called the Families First Coronavirus Response Act. And under that law, there is now also an emergency paid sick leave of up to 40 hours of paid leave for only some circumstances. And the circumstances are essentially that you're tested positive for the virus, that you're taking care of somebody who has the virus, that you have been ordered to quarantine by a health official, that the children cannot go to school because the schools are closed pursuant to a stay-at-home order. And there is one more that is to be defined by the U.S. Department of Labor. But the point being is that the emergency paid sick leave is available in certain circumstances. And we have to be mindful of two things. First, there was a requirement to put a poster, and we should put it up. It was supposed to be done by March, but let's just put it up now. And that this law is available until the end of the year, December 31st. And the reason why I make a big deal out of that is because right now, for example, school is not in session for most schools. But there may be some summer school, and come the fall, the schools are going to be back in session. And one area of this law says that if the worker cannot come to work because their children are not in school, that they are entitled to a paid Family and Medical Leave Act. So there was an expansion of the FMLA rights, which typically don't apply to small employers, which now, because Congress said so, will apply to small employers, and it will be FMLA with pay because of COVID. So we have to be mindful that there's a special requirement, and there is an expanded leave at least until the end of 2020. The next area is that we have to make sure that our workplace safety policies are up to date. What does that mean? In California, employers are required to have an injury and illness prevention program, right? And we all have one, right? So if I ask you for your IIPP, you have one available, right? Well, most companies don't have one just because, but this has become now a big deal because these orders are issued by the healthcare officers of each county. And if they come and do an inspection, they're going to ask you for your program. And if you don't have it, well, that's an area of concern. So there's a website, and I don't know if we have the link on it on the materials, but we can definitely share it, where Cal OSHA has a handy dandy e-tool where if you answer certain questions, the software, the program will generate a sample that you can use for your business. My recommendation, do that so you can have it. And in addition to the program that is required by Cal OSHA, you should also have the COVID-19 prevention plan. We gave you a sample as a good first start. Consult with your friendly neighborhood employment lawyer, tailor it to your business, and you should be okay from the compliance point of view. But other than compliance, I think we need to talk about rehiring and bringing people back. Shannon?
Sure. So yeah, the next step is you may have furloughed some of your employees during all of this, or you may have terminated and now looking to rehire. And you want to be really careful what kind of criteria that you're using. Just be mindful that it's not discriminatory, that you're using some kind of neutral criteria or a criteria that can really be justified for business reasons. So for instance, you don't want to just, bring back all the, young workers and not any of the older workers. And then also look at that list of who you're bringing back and see if there's possibly some kind of discriminatory impact or what's called a disparate impact. Does it look like, even though you're using neutral criteria, that you've left off all the women or anything like that? So you just want to be mindful that you don't get caught in any sticky situations, any sort of raising any eyebrows on who you selected and who you didn't. The next thing is you might have some people who don't want to return. Some people are afraid to go back to work. And what you should tell your employees is that you are creating a safe environment, that you're taking all the precautions, that you're complying with the law, educate them on your COVID prevention plan. But if they're still not comfortable, you know, my recommendation is you don't push it. That they don't want to come back to work, then don't, you know, don't force the issue. The safest thing is if you had put them on leave, is just to let them remain on leave, and let them know, okay, you can stay on leave, but I may need to fill that position, because obviously you need to still conduct your business and move on forward. And that position may not be available once that individual does later decide that they are comfortable. And in that case, you should really document this conversation, just so you have something, you know, in writing to protect you in case this individual tries to claim, oh, I was pushed out and fired and, you know, retaliated against or whatnot. And then you're going to have, you know, there's also been the discussion of what about high risk people, employees that you know are in a high risk category, 65 or older, or have a serious underlying condition. The EEOC has issued guidance on some of these questions on what you do with those individuals. You cannot refuse to return them. So you cannot just have a policy where you're just not returning anybody on that, based on that reason that they have, that they're at higher risk. The ADA does not mandate that you ask them if they need an accommodation, but if you're concerned, and I think it would be a good practice to, you know, if you know you have employees that have a disability that makes it higher risk, to ask them if they need any kind of accommodation and to get that conversation started. You know, it's not a time to basically survey all your employees and say, hey, everybody, you need to disclose your disabilities. No, you can't do that. What the EEOC has said, because, you know, we're dealing with a pandemic here, we can ask about some information, but it's not a free-for-all. We can ask about symptoms. We can ask if somebody has a fever, you know, something that's related to COVID-19, but we cannot then just sort of dig into people's medical history. And also just to remind you to keep that information private, whatever information that is being disclosed, that's still confidential medical information. And I think Javier is going to talk to us about leave and accommodation requests.
Right. But before I do, Shannon, I would like to make a comment on what you said. I agree with you 100% that the safest route is to document the measures that we have taken to provide a healthy and safe work environment within the circumstances, and to allow people to continue on a furlough, but to let them know that if and when they choose to come back, the job may not be available. So it is on them. We are going to be flexible as employers, but they should be mindful that their job is essential and necessary. That's why we're calling them back. And if they choose not to come back, that's fine, but we may need to hire someone else. And if we do, if and when they come back, the job may not be there for them. That's one way to handle it. That's the way I like it. That's what I would do if it was my business. But the reality is that California is an employment at will state, and you can fire somebody for no reason, with or without a reason. So if you call them back and they don't want to come back, you can fire them, terminate their employment, give them a last paycheck, and that was it. Bye-bye. Now, that's more aggressive, more risky, because employees have the right to be accommodated if they have a medical condition that needs accommodation. But separate from that, right? Separate from that, the question is, can they refuse to come back? And the answer is maybe. If they have a legitimate fear for their health and safety, an employee can refuse to come back. And if we fire them, that will be a violation of their rights. That will be retaliation, right? So what is a legitimate fear of infection? I don't know. So that's why leaving them on a furlough makes sense, because we're not pushing the issue, but be mindful that you could push the issue, because if you're taking the measures, if you're following the guidance and you need the person back, you might just make the decision of termination. And this comes to a head when now we have a situation that we have an emergency unemployment insurance benefit that is going to last until the end of July. And some people, it has been reported that some people are making more by staying at home than by working at minimum wage, right? So some people are saying, hey, I'm going to stay home and collect my unemployment, see you in August, right? Can they do that? And the answer is maybe. And here's why. The federal government has said that anybody who refuses to come back to a job are not going to qualify for the emergency unemployment insurance. But the state of California has said that if somebody fears for their safety and they don't want to come back because they may get infected, they will still continue to qualify for California unemployment insurance. So unemployment insurance is administered by the EDD. I wouldn't enter in that debate. That's an employee EDD issue. I will leave it alone. Don't touch it. But we have to be mindful that that dynamic is happening. So if somebody comes and said, hey, I just want to stay home and collect unemployment, well, my recommendation is document the measures that you have taken. Make sure that you can prove that you have a safe work environment, because that's the only reason why a person may refuse to come back. So by documenting in writing that you have taken measures, then that argument and door should be closed. Now the next level in the decision is like, are we going to allow them to continue on furlough? Maybe. Or are we going to terminate their employment? Maybe. This is a business decision. But it's important for me that you are aware that you have options as a business owner, as an employer, to deal and manage your workforce, because the reality is that if you cannot bring 100% of your employees and you have to pick and choose between who's coming back, it is important that you have the flexibility that you need to staff your business as appropriate. Having said that, Shannon, I don't know if you want to say something in response.
No, I mean,
sorry, it seems like a really fine line. I mean, that the employers really kind of got some challenges in these decisions. I mean, that's why I agree with you guys. I mean, documentation is going to be key, because if you have at-risk employees that don't want to come back, it's true as an at-will state, but I don't know. I feel like the employers just have a real fine line to look at here, and have to be really careful in their documentation and going forward. Wouldn't you agree?
Oh, definitely. And I think a lot of this also depends on the individual circumstance and who the employee is, and if there's any extenuating circumstances. But yeah, sometimes with these leave issues, employers will say, well, I really want to terminate them. And sometimes, I'll ask, well, why? If they're not getting paid, it's what is the rush? Because the safer thing could be just to let them stay on that leave. If you're not paying them, to just let them stay on that leave, because as soon as you terminate, it can bring a whole can of worms. But Javier's right, and that's a business decision that you need to make. And then as far as unemployment, I would just, the employer's going to get a form to fill out responding. And what I would advise is that you fill out that form truthfully and let EDD make a decision. EDD will make the decision on whether they're entitled to the unemployment or not. And I wouldn't get bogged down in that.
But some people want to, so that's why it's an option. Having said that, I think it's important. We can spend the whole afternoon talking about employment law, right? But on the highlights, what is it that you need to know? I think that's something that you need to know and take away to your business today, is that the law which protects people with medical conditions in California or disabilities under the federal law, the ADA and the FEHA in California, they're still on the books. And what that means is that people who have a medical condition or a disability, the employer has a duty to engage in an interactive process to try to determine if there is a reasonable accommodation that would allow the employee to do the job with a reasonable accommodation. And in the world of COVID, that looks like if somebody has an underlying critical condition that will make them vulnerable to the virus, we may need to engage in a process to try to find out whether we can accommodate that, right? So for example, one of the exceptions of wearing a face covering is that if somebody has trouble breathing or they have a condition that doesn't allow them to have their mouth and nose covered, they may not be able to wear a face covering. So if I have a cashier that by the guidance is required to have a face covering, but that cashier is telling me that he or she can't wear a mask because of a medical condition, what should I do? Well, you should try to engage and see if there's a reasonable accommodation. For example, if they cannot be at the cashier position, client facing, do we have a job on the back of the house that they could do? Maybe that may be reasonable, but it may not be reasonable. Maybe we don't have a position in the back of the house, or maybe we cannot allow for telework, or we cannot allow them to work remotely. Maybe we put them on a furlough, that's reasonable. So all of these are case by case, circumstance by circumstance basis, but it is important that as a business owner, you know and are aware that the right of the employee to find an accommodation is there, and the employer has the duty to engage in the process to try to find an accommodation. And there has been already some lawsuits published published cases where some people have had medical conditions and they have made the allegation that their employer failed to follow the process, that the employer did not try to find an accommodation, and that's a source of legal liability. Now, we would like to talk to you all about, in the last session, of the wage and hour concerns that deal with employment law, because every time somebody works for your benefit, they have to be compensated. Every single minute has to be paid. We used to have a theory that said that if it is too small, who cares? It's de minimis, as they say in Latin, so it's okay. That rule is no longer valid in California. Every single minute must be paid, and we have to ensure that every single minute for the benefit of the employer is paid. So if I ask my employees to do the self-check at home and to see if they have the symptoms, and they can do it by following the poster that we looked at, or they can do it by following a CDC website. Actually, on the CDC website, there's a tool where you answer some questions, and the website will tell you whether you have symptoms or not, or you should see a doctor or should get tested. If we ask the employee to do that at home, do we have to pay for that time? I would, because it's for the benefit of the employer. The flip side of that, if I am going to take the measurement of the temperature when people show up, if I'm going to ask them to complete a questionnaire when they show up, I have to make sure that they get paid for the time that it takes to do that, right? So we have to be mindful of every single minute being paid. And I wanted to say that because it tied to the accommodations, to the adaptations that are required under the guidance. Shannon?
Right. So anytime that the employees are spending, as Javier said, putting on the protective gear or washing their hands, doing any of the extra cleaning around the store, that will all need to be compensated. The other thing to keep in mind is something called reporting time pay. If an employee is scheduled to work and they show up and let's say, you know, you've changed the schedule last minute and send them home, they're entitled to, if they're getting less than half a day's work that they're scheduled for, they're entitled to reporting time pay of a minimum of 2 hours and a maximum of 4 hours. So just keep that in mind if you have schedules changing last minute. Another thing to keep in mind is classification of employees is exempt versus non-exempt. That means, I guess sometimes people call it hourly versus salary. My guess is you probably don't have a lot of non-hourly, you know, exempt employees due to the nature of work, but let's say you have a manager that you've classified as exempt. Just make sure that they still fit under that classification. In order to be exempt, there is a minimum salary threshold. They have to be paid salaried and paid twice minimum wage. And then they also have to be doing certain types of job duties. Supervise, so in sort of the managerial exemption, or also called the executive, they have to be supervising at least 2 employees. They have to have the ability to exercise independent judgment discretion. So they can't just be following orders. They have to have the ability to hire, fire, or have their opinions give a lot of weight to those decisions. So if you've changed a position and somebody who is really a manager is now just kind of like a line employee, they're no longer going to qualify under that exempt classification, and you need to start making sure you're tracking their hours and paying them for overtime. So just something to watch out for. Lastly, the business expense reimbursement issue. So this might seem silly to some people, but you know, the face coverings, that's actually, it's something required for work now. It's actually a business expense. You may be providing the face coverings to people, to your employees, or you may be saying, you know, we'll reimburse you, but you should do one or the other. Also thermometers, if you're requiring employees to do that temperature check at home, reimbursing them for thermometers. These types of little things can become big problems when plaintiff's attorneys, one of the claims they like to bring is called PAGA, which stands for the Private Attorney General Act. And basically an employee can bring a claim on behalf of all the other employees. And it's not a class action. It's sometimes referred to as a class action light. And those penalties can really stack up. So those little things can become big things. So just something to keep in mind to make sure that you're still reimbursing or covering those types of business expenses. Javier, did you want to add anything?
I have a couple of comments concerning the cost of the face covering. I agree 100% that because it is mandated and there's a strong recommendation by the county that should be paid by the employer. And more importantly, if we are going to then ask, because I've seen coverings that are $2 and I've seen coverings that are $75, you know, like everything, right? There's a market. But the point that I want to make is that if you are going to say, okay, everybody's going to wear the same one, right? Be mindful that that could become a uniform, right? Because if you just say, hey, we just want a black one, like shoes, it's not a uniform. But if you're going to say, we want the company logo on it, well, maybe it is a uniform, right? So we have to be mindful of covering that expense. Also, Shannon, I wanted to say something about something that you mentioned about salaried employees or people who are exempt in the retail area. There has been many cases that deal with store managers. And let me just say that in my opinion, it is very hard for a store manager to be really a salaried employee who's exempt because of the nature of retail. And when you look at what the wage orders say, most store managers and people in retail do manual tasks and they do things with their hands that will go through the threshold that will deprive them from being exempt. To be clear, even if they exercise discretion and independent judgment, even if they make more than what they should make because of what retail people do, it is very, very hard to have an exempt store manager. Just saying that there's a lot of litigation, so this may be the time to revise that to avoid issues in the future, because the reality is that the Private Attorney General Act, or PAGA, that allows for the stacking of penalties, and that is right now the hot button issue, I think. I think that all employment lawyers are dealing with too many PAGA cases. And if you can avoid it, why not?
Right, and the thing I should have added onto that too is, in order to meet the exemption, the employee has to be spending more than 50% of their time on those managerial duties. So as Javier said, that can be difficult because if they're spending most of their day just doing transactions, checking people out, then they're not going to meet the exemption. So like Javier said, you just want to flag that and make sure that that's correct.
All right, so I'm happy that we covered what we really, really wanted to cover, because these are the things that you must know and you must take away and take them home. But Chris, since we have a few minutes, maybe we can take some questions.
Yeah, I guess the question came to my mind, and I mean, is the recommendation now to, in essence, provide face masks and thermometers at home as a business expense? And what's the safe way for a retail business to deal with that issue? That'd be the question I have. Is that basically the recommendation now?
Shannon?
Well, I think you can do, I mean, as far as the thermometer, some businesses are doing the temperature checks themselves. They're doing them on site with a contactless thermometer. I haven't really seen, one been, people saying one's better than the other. I mean, one thing to keep in mind is if they're doing it at home, it is compensable, right? So as the employer, maybe you have some more control over how people are calculating that time or doing it on site. But I think it's really just depends on the business owner's preference.
From my perspective, because the guidance say that you can do one or the other, either temperature or screening, and the screening could be at home. If it was me, my business, I would do both. And this is what it looks like. Anybody who walks in the door, they're gonna get their temperature checked. And let's be honest, the first time somebody put one of those things in my forehead, it was jarring. So we need all to adapt to this weird situation, but I will do that. Anybody who walks in the door, they're gonna get their temperature checked. And I would give the education piece to the employees and say, these are the symptoms. Before you show up, make sure that you don't have any of those. And if you do not come to work. Let's just talk later about whether you're gonna get paid or not, but do not show up to work if you have any of these symptoms, right? If you're sick, don't come to work. And that may seem like an overkill, but no one can point the finger at you to say that you failed to take actions to prevent the spread of the virus and that you're liable for failing to act. Now, one thing that I wanted to say in the introduction, I think I forgot, is that when we're talking about the duty of the employer with the employee, it is the obligation of the employer to make sure that the employees are safe. In my opinion, you do not have the same duty towards the public. So when somebody walks into your place of business, you don't have an obligation to make sure that they're safe. But if you are negligent and you fail to take actions, or you take actions that are negligent, you may be liable to the public in general as well. And by following these guidelines, you should be okay with your employees, and you should also be okay with the public, because you're gonna go above and beyond what is a reasonable person would do. Again, brings us to the what should I do? The more you can do, the less and the more far away the attorneys are gonna stay from you, right?
Well, it kind of circles back. At the end of the day, it's just important to understand the guidelines and err on the side of the strict guidelines. Err on the side of caution. And I think if you do that, you have protected yourselves from liability from within your business and also to the public. Is that kind of a fair characterization?
Yes, and in my opinion, it's the message that I want to deliver is that don't panic. This is not that people are out to get you, but if you do nothing, they're going to get you. So do something within reason, in good faith, and you should be okay, because this is about risk management and managing the risk within the knowledge and awareness that we have an obligation towards the employees. So the more you can do, the better. And that's why we have some tools. That's why we put up together as an organization. And thanks to our sponsor, we can put up this webinar, right?
Right. And a shout out to Jador. I just want to, just kind of to conclude, I just want to thank you, Javier and Shannon. Now, if you guys have any questions out there, certainly Javier and Shannon are locally here based employment attorneys that would be happy to, I'm sure, take your questions. I also, for a housekeeping matter, want to say that this is going to be available. It will be sent to all attendees by email and also on our website at the San Clemente Downtown Business Association. It's www.scdba.org. So I want to thank our attendees, thank you panelists, and also a preview. We are going to do the third part of our webinar series next week, same time, Thursday at noon. It will be concentrated on getting back to the office. And I know these laws change by the day, so get the most updated information. So thank you, Javier. Thank you, Shannon, for your great information today. Thank you so much.
Thank you.
Thank you. And thank you to the DBA.
All right, thank you.